Story. 2 kids inherit a house. One lives in the home, and the other wants to sell it. Now what? I'm Valerie 𝗦𝗶𝘀, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Before we get into the answer, I'd like you to think about a friend who's challenged with a what-if scenario that creeps into their lives, but you shared our video, and it helped them greatly, and so they were better prepared. We would appreciate it, as will your friend. Now, while there are a number of ways to figure out this quandary where one sibling lives in the house that they inherit and the other wants to sell it, the easiest way to satisfy all parties initially is by having the tenant sibling pay rent at a fair market value, well, 50% of the fair market value, because the tenant sibling already lives there or inherited 50%. So the 50% owned by the other sibling, they'd be paying rent for less probably 50% of the expenses that the tenant spouse paid, tenant sibling, excuse me. Essentially, they have to work out where there's a fair rent being paid to the non-tenant sibling. In the long term, however, it does get a little trickier. Now, what happens if the tenant spouse, I keep saying spouse, sibling, puts in money to create capital improvements in the home because they're living there, they want to enjoy it? Well, that increases the value, but the sibling that didn't live there didn't make that contribution. And what happens if the tenant who's living there actually depletes the value in the home with the way that they handle things and treat the home? It can create a long-lasting issue for both parties. So the first solution when it comes to satisfying the goals of the two parties would be to see if the tenant sibling who's living there wants to keep the home can actually purchase the other 50% from the other sibling. This can be done in a couple of ways. They could substitute what they've received or would have received elsewhere from their inheritance. But if there's not enough of other assets to do that, they have to come up with that funding themselves or through lending. This is not always possible where that tenant sibling is able to pay the other siblings for their interests in the property. And so if the parties are not able to come up with a fair resolution on when to sell, it's possible that the non-tenant sibling will have to file what's called a partition action. So it forces the sale and division of that property. We don't like to see that happen, but it does on occasion. We hope that you've learned something new here today. You choose to share. And as always, we hope that you take care.